Thank you very much. Thank you to the European Institute for the kind invitation, and thank you in particular to Valentina Bettin for her kind cooperation. And I wouldn't like to disappoint you, but I am not the Perm representative of Italy. I'm just the legal advisor and of the Perm representation of Italy to the European Union. And so my paper is divided in 8 parts. I'm not going to summarize it. It would be quite difficult. And I just would like to raise a couple of questions, trying to give you some answers. And the first problem I'd like to raise is that why this 17 plus international agreement has been concluded. It was clear in October 2011 at the European Council that a limited revision of primary law was envisaged as a key action. But as Bruno, De Witt, and some other speakers yesterday rightly pointed out, it was not possible. Of course, the main concern of the discussion in Brussels was that the fiscal compact was a means to solve specific problems of the Eurozone states. But it was plain that any revision of primary law had to be done without affecting the position of the non-Eurozone states. However, the requirement of the unanimity requirement soon proved hard to achieve, since in the first part of 2011 it was clear that the United Kingdom would have prevented any resort to Article 48. Of course, other paths were conceivable, such as measures adopted under Article 1336 of the Treaty on the Functioning, revisions of Protocol number 12, and even enhanced cooperation acts could be envisaged. However, it was, to me, and you have to put the discussion we had in a context, in the historical context. In that very moment, we had a balanced budget rule to put in this new instrument. It was a demand coming from Germany, the virtuous state, Germany, Finland, Luxembourg, and so on. That point was raised as it was necessary to put it at constitutional level. So it would imply some amendments to national constitutions. It was clear in the summit of October 26th of 2011. We had some doubts about whether it would be done, that reform could be done through secondary law acts, because under the Lisbon Treaty, even for Eurozone states, the competence of the Union is basically a competence of coordination and surveillance of budgetary policies. And even considering the peculiarities of Article 136 of the treaty, this legal basis cannot be used as a tool to modify Protocol number 12, because if you envisage a budget to include in the new treaty, in the new instrument, a balanced budget rule, then you are going to affect, to have an impact on Protocol number 12. Then you have, so if you look carefully at Article 136, paragraph 1, it's clear that whenever you touch upon the protocol number 12, you have to use the clause provided for in Article 126, paragraph 14. Then you come to, again, to unanimity. It was a major problem considering the UK position. Moreover, one may ask whether such a competence, the competence of the European Union in this field, which is a peculiar kind of competence to me, is not an exclusive competence, not a shared competence, it's something different from this one. However, whatever it may be, one may ask whether such a competence includes an obligation implemented at constitutional level touching upon the autonomy of executive powers and national parliaments to define domestic budgets. And that leads to the consequent consideration, according to which a balanced budget rule may affect a constitutional value of some member states as long as it poses relevant constraints in terms of determining public revenue and expenditure. After all, the Union is deemed to respect the constitutional value, constitutional identity of its member states according to Article 4, paragraph 2 of the Treaty of the Union. And although I admit that the concept of national identity as embedded in domestic constitution is rather vague, in that very moment, at the end of 2011, one couldn't avoid recalling two lengthy rulings of the German Constitutional Court that shaped some limits to the European integration. In particular, the Lisbon Urteil, the German Constitutional Court ruling on the Treaty on Lisbon, held that revenue and expenditure, including external financing, were included in domestic jurisdiction of Germany to be respected by the EU as part of its national identity. And in the slides you may find paragraph 252, where the German Constitutional Court referred to the fundamental fiscal decision as well, and so on. According to the court, there are at least 5 core areas of national competencies. So, in that respect, at the end of the day, the direct involvement of national parliaments through their constitutional processes of ratification is, in my understanding, a far better solution instead of using secondary law tools. I would like to make a point concerning, I'm not going through that in particular, but there is a point which was raised in the discussion we had yesterday in the afternoon, according to which is there one Article 7 of the Fiscal Compact concerning the so-called reverse qualified majority. So one argument was made according to which it's true that is the point I addressed in my paper, and so the point was, since the six-pack introduced the reverse qualified majority in the excessive deficit procedure, so actually there is no point in raising the legal problem based on Article 7 and in the so-called default ruling in Article 16, paragraph 3 of the Treaty of the European Union. But if you look carefully on the regulation regulation 1173, it is true that twice the so-called reverse qualified majority has been introduced in the excessive deficit procedures. but without affecting Article 126, when the Council is required to decide on positive qualified majority. If you look at Article 5.2 of this regulation, 1173, 5.2, 5 paragraph 2, and 6.2, you immediately realize that first of all, the Council decides on a positive qualified majority, and the subsequent, and the wording is the same, further decisions of the Council are adopted under the reverse qualified majority, and they are conceptually figured out as a sort of implementing measures of a decision already taken by the Council. And then conceptually you are within the Article 291 of the treaty, and that can be done. But of course, the point is that you can't, by the means of secondary law act, you can't affect primary law. It's so simple. Now let's go to the second question I'd like to raise. Does the fiscal compact risk widening the democratic deficiency of the euro? Oh my God! Very carefully. There are Article 3 concerns the balanced budget rule. Article 4, the obligation to reduce public debts. You have even a lot of constraints posed to the states, to the Eurozone states, and Article 5, it's clear an obligation to submit to the Council, to the Commission and the Council, a budget and economic partnership program, including a detailed description of structural reforms. So a lot of constraints are posed on member states. And the point is that all these, the problem is that these constraints do not flow from a mature democratic political process. Indeed, the normative instruments adopted to tackle the financial crisis show structural shortcomings in terms of democratic legitimacy. This seems all the more so if one considers the limited role reserved to the European Parliament and economic governance of the European Union. In this scenario, more democratic legitimacy can be injected by means of a national system, as the Bundesverfassungsgericht rightly demanded with regard to the rescue funds instruments recently adopted to tackle the crisis. However, this is true only if national parliaments have the strength to effectively scrutinize the respective governments, even assuming the full implementation of the rule, Article 13 of the Fiscal Compact. That is to say, the joint discussion between national and European parliaments concerning the budgetary policy, all the issues related to the Fiscal Compact. Even assume that would, in my understanding, wouldn't be the panacea for recovering democratic accountability. Moreover, we have the role of the Commission is enhanced. I just mentioned two points. One, the Commission, according to Article 3 of the Fiscal Compact, has to adopt common principles to complement the correction mechanism that Eurozone states have to set up. When they deviate from virtuous budget action, then you have Article 7, and you know. So the point is that we are increasing the normative role of the Commission, and one may wonder whether the Commission enjoys a full-fledged democratic mandate to play such a prominent role, being it still a semi-technocratic institution. In the meantime, the European Parliament, representing the European citizen directly, doesn't emerge as a net beneficiary in the Fiscal Compact, whereas the decision-making power of governments is reinforced. It's not to say, I'm not saying that governments are deprived of democratic legitimacy, but that their legitimacy depends upon effective accountability to their national parliaments. Being legitimacy a concept with variable intensity per se, I believe that legitimacy may be enhanced by injecting more accountability of the decision-making process towards the European Parliament. The Fiscal Compact Treaty shows that the Eurozone is embracing a culture of financial stability aimed at preserving common currency as a fundamental achievement of the European Union. It shows also a serious commitment to consider the euro as an essential and irreversible normative value of the European integration, even in terms of competencies conferred to the institutions. You have to recall the declaration made by member states immediately after the signature of the Fiscal Compact, showing that they considered the euro as an irrevocable achievement. And so Mario Draghi has pointed out several times afterwards. By preventing, I do have a favorable approach, a favorable personal opinion concerning the Fiscal Compact, because it prevents the elites governing a country from adopting unethical debt-creating policies to be put on the backs of future generations. In this way, the Fiscal Compact speaks the language of social equity. Some says that even the Fiscal Compact speaks German. Probably it is so, but to me, it speaks even the language of social equity. Thus, it can be conceived as one of the basic elements of the social pact among generations, and to me is positive per se, since it protects national democracies from intergenerational conflicts. The point is that we have to search for a more mature governance of the Eurozone and trying to enhance more democratic accountability. Of course, it will be the challenge of the future steps of economic integration. The democratic governance of the euro needs to be improved so as to rely less on national legitimacy, inputs, and more on its own direct source of democracy, that is to say, the European Parliament. A genuine European Union, a genuine European political democracy does need it. So we have to, it will be the subject of some other seminar, how to modify the system, the European Union system. But of course, the credential in that case, if we achieve a political democracy, real political democracy in the European Union, then the democratic credential of the Union will then be reaffirmed and improved. Thank you.